Case 1. Julissa Thaler, May 20th, 2022, Hennepin County. There are moments in the history of a community when the weight of what has happened becomes almost impossible to carry. When the details of a case emerge not gradually, but all at once, flooding newsrooms, courtrooms, and kitchen tables with a grief so heavy it bends people. In Minnesota, in the spring of 2022, one of those moments arrived without warning. It did not come from a stranger lurking in the shadows of an unfamiliar neighborhood. It did not come from a calculated criminal with a long history of preying on the vulnerable. It came from someone who, by every measure society uses to define safety, should have been the one person standing between a child and harm. It came from his mother. Eli Hart was 6 years old. He had a name that carried lightness in it, a name that felt like something bright and brief and full of possibility, the way all children's names should. He had a smile that people who knew him described with the kind of language people reach for when words start to fail them. He was small. He was trusting. He was, in the way that all 6-year-olds are, entirely dependent on the adults around him to keep him safe in a world he had barely begun to understand. His mother was Julissa Thaler. And what Julissa Thaler did to Eli Hart on May 20th, 2022, would send a wave of devastation through Hennepin County, through the state of Minnesota, and through every person who would eventually hear this story and find themselves unable to look away. To understand what happened on that spring day, it is necessary to understand the months and years that led up to it, because nothing about this case appeared suddenly. There were systems involved. There were decisions made by adults in positions of authority. There were hearings and filings and rulings. And at the center of all of it, moving through each stage with the quiet endurance of someone who had no voice and no choice, was Eli. Eli's life before May of 2022 had not been a simple one. His early years were marked by instability, and Minnesota's child protective system had been involved with his family on more than one occasion. At some point prior to the events of that spring, Eli had been removed from his mother's care and placed in a different living arrangement, one that, whatever its imperfections, kept him alive. There were people who knew Eli during that time, people who watched him grow and laugh and be a child, people who, in the months that followed, would have to live with what they knew and what they could not have anticipated. In the period leading up to May 20th, Julissa Thaler had been working through the legal process of regaining custody of her son. Family courts in Minnesota, as in most of the United States, are guided by a principle that prioritizes the reunification of biological families when circumstances are deemed to support it. The system, in its procedural architecture, is designed with good intentions. But good intentions and good outcomes are not always the same thing. In Eli Hart's case, the distance between those two things would prove to be irreversible. Court records indicate that just days before May 20th, 2022, Julissa Thaler was granted full custody of Eli. After the legal process had run its course, after the paperwork had been signed and the decisions made official, Eli went home with his mother. For those who had hoped the reunification would mark a turning point, a new beginning, a chapter in which a family was rebuilt and a child was finally settled and safe, those hopes would not survive the week. On May 20th, 2022, Eli Hart was placed inside a vehicle driven by Julissa Thaler. What happened inside that vehicle has been established through the subsequent criminal investigation and the proceedings that followed. Thaler was in possession of a shotgun. She discharged it 9 times. Eli Hart, 6 years old, did not survive. His body was placed in the trunk of the vehicle. When investigators and legal analysts later attempted to describe the nature of what Thaler had done, the premeditation, the proximity, the sheer number of times she acted with deliberate intent, the language of the courtroom struggled to contain it. 9 times. A 6-year-old. The child she had just been handed back by the very system meant to protect him. After the shooting, Thaler drove. She did not immediately contact authorities. She did not go to a hospital. She did not stop at a neighbor's house. She drove with her son in the trunk, and she kept driving until the vehicle came to the attention of law enforcement during a traffic stop in Mound, Minnesota, a western suburb of Minneapolis located along the shores of Lake Minnetonka, roughly 20 miles from the city center. The stop, routine in the way that all traffic stops begin, became something else entirely when officers discovered what was in the trunk. The discovery of Eli Hart's body in Mound on May 20th, 2022, triggered one of the most significant homicide investigations in Hennepin County's recent history. What investigators confronted at that traffic stop, the reality of what had been done to a 6-year-old boy, and the circumstances under which he had been placed in harm's way, would shape not only the prosecution that followed, but a broader public conversation about child safety, family court systems, and the profound consequences of institutional decisions that cannot be undone. Julissa Thaler was taken into custody. The investigation that followed was extensive, and the charges that were ultimately brought against her reflected the severity of what the evidence showed. She was charged with first-degree premeditated murder, the most serious classification of homicide under Minnesota law, reserved for acts that are not impulsive or reactive, but planned, deliberate, and carried out with intent. The proceedings in Hennepin County moved through the legal system over the months that followed. The evidence presented was extensive. The prosecution's case rested not only on physical evidence and the circumstances of the traffic stop, but on a foundation of documented history that the court would consider in the context of what Thaler had done. Witnesses testified. Documents were entered into the record. The full weight of what had happened to Eli Hart was placed before a judge. In February of 2023, less than 1 year after May 20th, a Hennepin County judge handed down a sentence that reflected the finality of what the court had determined. Julissa Thaler was sentenced to life in prison without the possibility of parole. In Minnesota, there is no penalty beyond that. It is the law's most complete response to the most complete act of harm. A sentence that says, in the clearest possible legal language, that what was done cannot be walked back, cannot be mitigated, and cannot be forgiven within any framework the system is designed to offer. Life without parole. For the premeditated taking of a 6-year-old child's life. For the 9 shots fired inside a vehicle on a May afternoon. For the drive to Mound with Eli in the trunk. For the days that had come before. The hearings, the rulings, the paperwork that had placed him back in her care. In the aftermath of Thaler's sentencing, the case became a focal point for broader discussions in Minnesota about the child protective system, the standards applied in custody reunification decisions, and the mechanisms available to advocates and caseworkers when they have concerns about a child's safety. Legislative conversations were prompted. Community organizations that work in child welfare cited Eli Hart's name in calls for systemic reform. His story, the brevity of his life and the circumstances of his death, became part of a larger reckoning that the state of Minnesota is still, in many ways, working through. For the people who knew Eli Hart, who watched him play, who heard him laugh, who fed him and read to him, and held the ordinary moments of his short life, no sentence, no legislative reform, no documentary segment can reach the place where grief like that lives. There is no resolution at that depth. There is only the endurance of those who loved him, and the commitment to make sure that his name is remembered not as a statistic, but as a life that mattered. Eli Hart mattered. He was 6 years old, and he deserved every single day that was taken from him. The Hennepin County court system's response to this case was the strongest available under Minnesota law. And while the law has done what law can do, the community that surrounds cases like this one, the advocates, the social workers, the foster families, the neighbors, the people who sit with grief and transform it into action, carries the longer responsibility. If you are watching this and you work with children, know a child in an unsafe situation, or have concerns about a young person's well-being, please reach out to the Child Help National Child Abuse Hotline at 1-800-422-4453. They are available 24 hours a day, 7 days a week. You may be the person who makes the difference. Eli Hart deserved better. The system that failed him deserves our honest examination. And the justice handed down in Hennepin County in February of 2023, permanent, final, irreversible, stands as a statement that Minnesota's courts understood the weight of what was brought before them. If this case moved you, please take a moment to like this video, leave a comment below, and make sure you have subscribed to Cold Case Hour. Your support keeps this channel going and ensures these stories are never forgotten. Case 2. Kellie Jo Anderson, April 23, 2020, Clay County. There is a particular category of trust that exists between a child and the adult who takes on the responsibility of their care. It is not biological. It is not written into law in any document a child can read or understand. It is simply the trust that a very small person places in the very large world around them, assuming, as children must assume, in order to survive, that the adults who hold authority over their lives will use that authority to protect them. For 18-month-old Henry Thomas Anderson, that trust was placed in the care of a woman who carried his last name without sharing his blood. And on April 23, 2020, that trust was broken in ways that no child should ever have to endure. Kellie Jo Anderson was 36 years old at the time of the events that would define the rest of her life. She lived in Barnesville, Minnesota, a small community in Clay County in the western part of the state, a place far removed in geography and character from the urban centers of the Twin Cities, but not far removed from the same human struggles, the same systems of child welfare, and the same potential for catastrophic failure that can occur wherever people are. Barnesville sits in agricultural country, the kind of landscape that evokes a certain quietness, a certain distance from the noise of larger cities. Henry Thomas Anderson was placed in that setting as a foster child, in the care of a woman the system had deemed qualified to provide for him. Foster care, at its best, is one of the most important institutions a community can maintain. It is a response to circumstances that have already gone wrong, a net designed to catch children who have fallen through other nets. The people who enter the foster care system as caregivers take on a responsibility that the state officially entrusts them with, a responsibility that is monitored, reviewed, and meant to be subject to oversight. When that system functions as intended, children in crisis find stability, warmth, and a bridge toward a more secure future. When it fails, the consequences are borne entirely by the most vulnerable people involved. Henry Thomas Anderson was 18 months old. At that age, a child is in the full flowering of early development, learning to walk steadily, beginning to form words, discovering the world through touch and taste, and the boundless curiosity that defines toddlerhood. He was small enough to be held in one arm. He was old enough to have preferences, to recognize faces, to reach toward the people he associated with safety and comfort. He was utterly dependent on Kellie Jo Anderson in the way that all toddlers are dependent on their caregivers, completely, without reservation, without any mechanism for self-protection. On April 23, 2020, inside the home in Barnesville, something happened to Henry Thomas Anderson. The details of what Kellie Jo Anderson did that day were established through the subsequent investigation and the criminal proceedings that followed. What the autopsy determined, what the medical examination of Henry's small body revealed, was a picture of harm so extensive that investigators and medical professionals who reviewed the findings were left without ambiguity about what had occurred. The autopsy findings documented a combination of asphyxiation and severe physical harm. The internal examination revealed evidence of serious internal injury, a fractured jaw, and broken ribs. These were not the kinds of findings associated with accidents. They were not the kinds of findings that could be explained by a fall or a moment of carelessness. They were findings that told a story of force applied to a toddler, of harm carried out against someone who could not defend himself and could not ask for help. Henry Thomas Anderson did not survive the events of April 23, 2020. The investigation that followed involved Minnesota law enforcement and child protective authorities. The death of a foster child in the care of a licensed caregiver triggered an examination not only of the specific acts that had led to Henry's death, but of the broader circumstances surrounding his placement and the oversight that had or had not been present leading up to that day. In cases like this one, the investigation necessarily extends beyond the individual actions of the offender because the system that placed the child in that home shares in the weight of what happened to him. Kellie Jo Anderson was arrested and charged. The case moved through the Clay County legal system, and the evidence assembled by investigators provided a foundation for the prosecution that followed. Anderson ultimately entered a guilty plea to second-degree felony murder, an acknowledgement, in the language of the law, of her responsibility for Henry's death. In June of 2021, 14 months after the events of April 23, Kellie Jo Anderson appeared before the court for sentencing. She was 36 years old. The judge in the case reviewed the evidence, the nature of the harm that had been done, and the circumstances of the crime. The sentence handed down reflected the gravity of what the court had before it. Anderson was sentenced to 35 years in prison, 420 months, a sentence that would carry her well past the age of retirement, well past the ordinary markers of a life lived in freedom. 35 years for the death of an 18-month-old foster child who had been placed in her care. 35 years for the fractures and the internal injuries and the asphyxiation documented by the medical examiner. 35 years for the destruction of a life that had barely begun, a child who had been brought into the foster system precisely because the world had already failed him once, and who deserved the second chance that system was supposed to provide. Clay County's handling of this case, from the investigation through the prosecution and the sentencing, represented a serious engagement with the full weight of what had occurred. The sentence of 35 years signaled that the court understood what Henry Thomas Anderson's life was worth, and what the responsibility of a licensed caregiver means when it is violated in the most irreversible way imaginable. In the years since Anderson's sentencing, the case has been cited in discussions about foster care oversight in Minnesota, the training requirements for foster caregivers, the frequency and depth of home visits, the mechanisms by which warning signs are identified and acted upon before harm occurs. Henry's death did not produce simple answers to those questions. It produced harder questions, honestly asked, about a system that is perpetually under-resourced and perpetually asked to do more than any under-resourced system can reliably accomplish. What is certain is this: Henry Thomas Anderson deserved better. He deserved the stability and warmth and safety that the foster care system is built to provide. He deserved the chance to keep growing, keep walking, keep reaching toward the world with the open hands of a toddler who does not yet know that the world can close them. That chance was taken from him in Barnesville, Minnesota, on April 23, 2020, by the person who was supposed to protect him. The justice handed down in Clay County in June of 2021 will never be adequate to the loss. But it is the law's best response to a harm that cannot be undone, and it stands as a permanent record that Henry Thomas Anderson's life was seen, was counted, and was not forgotten. If this story has stayed with you, please like this video, leave your thoughts in the comments, and subscribe to Cold Case Hour. These children deserve to be remembered, and your support makes sure their stories reach the people who need to hear them. Case 3, Addison, Perdew, November 10, 2021, Hennepin County. There are investigations that begin with the ordinary and end with the unthinkable. Welfare checks, the routine visits that law enforcement officers make when someone has raised a concern about a person who cannot be reached, who may be in distress, who may need help, are among the most unpredictable calls that officers respond to. Most of the time, a welfare check ends with a conversation, a reassurance, a door closed again as the officer returns to their vehicle. Occasionally, they end with something that changes everyone present. On November 10, 2021, Minneapolis police officers responded to a welfare check at an apartment in the Seward neighborhood, a close-knit residential community on the city's south side, bounded by the Mississippi River Gorge and characterized by the kind of dense residential streets where neighbors know each other's faces, if not always each other's names. What those officers found inside that apartment would begin a case that would move through Hennepin County District Court and result in a sentence that reflected one of the most sobering realities a justice system can be asked to confront. Addison Sue Perdew was 23 years old in November of 2021. She was, by official measure, a young mother, a person in the earliest and most demanding stage of the particular responsibility that parenthood places on an individual. Her son, Akasha, was 2 months old. He had been in the world for approximately 60 days. He had not yet learned to hold his head steady or track movement across a room. He had not yet smiled in response to a face he recognized. He was, in the complete and irreducible sense of the word, an infant, a human being entirely dependent on the person responsible for his care, capable of communicating his needs only through the sounds available to him, and entirely unable to protect himself from any harm directed his way. When officers entered the Seward apartment in response to the welfare concern, they found Addison Perdew in a state of significant distress, heavily intoxicated and, as subsequent medical assessment would determine, experiencing the effects of a pill overdose. But it was not Perdew's condition that became the center of the investigation that evening. It was the discovery of Akasha. Akasha Hart, 2 months old, 60 days into the only life he would ever have, was found in the apartment. He had not survived. The investigation that followed, including a forensic examination conducted by the Hennepin County Medical Examiner, established what had happened. Akasha had suffered severe physical harm. The injuries found during the examination were consistent with a violent physical assault, harm inflicted upon an infant by a person with the physical capacity to cause it. Addison Perdew was taken into custody. The investigation moved quickly given the evidence present at the scene. Perdew was charged in Hennepin County with the death of her infant son, and the case entered the legal process that would take it through hearings, legal proceedings, and ultimately to a guilty plea. In her plea, Addison Sue Perdew acknowledged responsibility for the death of Akasha. The charge to which she pleaded, unintentional second-degree murder, carries a specific legal meaning that is worth understanding in the context of this case. Under Minnesota law, unintentional second-degree murder involves a death that results from conduct the offender was engaged in with conscious disregard for the risk to human life. It is distinguished from first-degree murder by the element of premeditation, but it is not diminished by that distinction in terms of the gravity of the outcome. An infant lost his life. His mother was present, and the forensic evidence established a direct connection between her actions and his death. In April of 2023, roughly 17 months after Akasha's death, Addison Sue Perdew stood before a judge in Hennepin County District Court for sentencing. She was 25 years old. The judge reviewed the facts of the case, the evidence presented, and the circumstances that had been established through the investigation and plea process. The sentence handed down was 21 years and 9 months, 261 months in Minnesota State Prison, 21 years and 9 months, for the death of a 2-month-old infant, for what was found in an apartment in the Seward neighborhood on November 10, 2021, for Akasha, who had 60 days. The Seward neighborhood, in the aftermath of this case, had to absorb a tragedy that was, in many ways, invisible until it was too late. There were no public signs of what was happening inside that apartment. There was a welfare check, someone's concern expressed through the appropriate channel, a call made because something did not seem right. That call, however late it arrived, brought officers to the door. The system responded when it was reached. But Akasha needed the system before it was reached, and that is the tragedy that sits beneath the specific facts of this case, and so many others. In the years since April of 2023, the details of Akasha's case have informed conversations in Minneapolis and across Minnesota about early intervention services for new mothers, particularly young mothers, first-time mothers, mothers who may be struggling with substance use or mental health challenges, or the simple, crushing weight of responsibility that arrives with an infant and does not pause for anyone to get their footing. The questions raised by cases like this one are not questions about evil in the abstract. They are questions about support systems that exist, and about the gaps in those systems through which the most vulnerable people, both mothers and infants, can fall without anyone realizing it until the welfare check comes too late. None of that analysis changes what happened to Akasha. None of it brings those 60 days back or extends them into the years they should have contained. But the honest examination of how and why these situations occur is itself a form of accountability, the community's accountability to the children who live and die within it. Addison Perdew will serve the sentence handed down by Hennepin County District Court in April of 2023. The law has done what law can do. And Akasha, 2 months old, a name that means something in this world even now, is remembered in the record of these proceedings, in the work of the advocates and systems that carry his case forward, and here, on Cold Case Hour, where his story will be told with the seriousness and dignity it deserves. If this story has resonated with you, please like this video, leave a comment, and subscribe to Cold Case Hour so you never miss an episode. Case 4. Esperanza Ray Harding, February 28, 2024, Hennepin County. The Minneapolis-St. Paul metropolitan area is one of the largest and most complex urban regions in the upper Midwest. A sprawling network of cities, suburbs, hotel corridors, transit routes, and residential communities that together form the economic and cultural core of Minnesota. Within that metro, Bloomington sits directly south of Minneapolis, home to one of the busiest commercial districts in the state, a city of parking structures and shopping centers and the kind of anonymous hospitality infrastructure, hotels, extended stay facilities, transient accommodations, that serves as a backdrop for an enormous variety of human experience. On February 28, 2024, inside one of those hotel rooms in Bloomington, A crime occurred that would result in one of the most heartbreaking prosecutions in Hennepin County's recent history. Mateo was 8 months old. He could not walk. He could not speak in words that carried their full meaning. He existed in that particular stage of infancy where the world is primarily sensory, where existence is measured in hunger and warmth and the nearness of the person his nervous system had learned to associate with safety and care. That person was his mother, Esperanza Ray Harding, who was 20 years old at the time of the events of February 28th. What investigators established through the course of their examination of that Bloomington hotel room, and through the evidence that followed, is a sequence of events that no responsible narration can approach without care. Mateo, 8 months old, was crying. This is what infants do. It is not a failure. It is not a provocation. It is the only complete language available to a child who cannot yet form the words for what he needs. Mateo was crying, and Esperanza Ray Harding's response to that crying was the decision that would end his life and define the rest of hers. Harding submerged Mateo in a bathtub. He was 8 months old, and he did not survive. After the infant died, Harding placed his small body into a backpack, left the hotel room, and discarded it in an outdoor dumpster, an act that, in its cold procedural sequence, revealed to investigators the premeditated nature of the decision-making involved. This was not a moment of chaos. This was a series of deliberate steps, each one building on the last, each one moving further from any possibility of undoing what had been done. Law enforcement became involved when Mateo was reported missing and the investigation moved to the Bloomington Hotel. The recovery of Mateo from the dumpster and the evidence assembled from the hotel room provided the foundation for the criminal case that followed. Esperanza Ray Harding was arrested. The charges brought against her reflected the intentional nature of what the evidence showed. The case moved through Hennepin County, and Harding entered a guilty plea to second-degree intentional murder, a charge that acknowledges that the act was carried out with the conscious purpose of causing death, without the additional element of premeditation that elevates a charge to the first degree. The guilty plea spared the court a full trial, but it did not spare the community, or the record, from grappling with the full weight of what had happened to Mateo. In March of 2025, approximately 13 months after February 28th, Esperanza Ray Harding was sentenced. She was 21 years old when she stood before the Hennepin County Court for judgment. The sentence the judge handed down was 32 years, 384 months in prison. For a 21-year-old, that sentence extends well into the middle of life. It is the law's way of marking, in temporal terms, the gravity of what was taken and the permanence of its absence. 32 years. For Mateo, 8 months old. For the backpack. For the dumpster. For the deliberate sequence of acts that followed an infant's cry in a Bloomington hotel room on February 28, 2024. The hotel, the anonymous, transient setting of this crime, became, in the context of this case, a symbol of something broader. The isolation of transient living arrangements, the invisibility of what happens behind closed doors in spaces that are not homes, the difficulty of community connection in environments designed for short stays. These are not excuses. Nothing in this case admits of an excuse. But they are context, and context matters when a community tries to understand not just what happened in one room on one night, but the conditions under which the worst outcomes become possible. Hennepin County's handling of this case, the investigation, the prosecution, the 32-year sentence, represents a clear accounting for what happened to Mateo. He was 8 months old, and he deserved every day that followed February 28, 2024, that was taken from him before he could live them. The advocates, social workers, and community members who work every day in the spaces between crisis and intervention, in the shelters and support services and anonymous phone lines where people reach out when they are struggling, carry the longer responsibility for making sure that the conditions that produce this outcome are understood and addressed with the seriousness they demand. Mateo deserved better. The law has spoken, and his name will not be forgotten here. Please like this video, leave a comment below, and subscribe to Cold Case Hour. These stories matter, and so does every person who takes the time to hear them. Case 5, Htoo, November 19, 2015, Ramsey County. Some cases resist simple categorization. They sit at the intersection of tragedy and accountability, in the difficult space where the facts of a crime are undeniable and the circumstances surrounding it are layered with a complexity that a community cannot afford to ignore. The case of Htoo in St. Paul, a city that shares with Minneapolis the geography, the institutions, and the human landscape of the Twin Cities, is one of those cases. It is a case about an infant who did not survive. It is a case about deliberate acts. And it is, simultaneously, a case about what can happen when a young mother's mental and emotional crisis reaches a depth that no available resource was able to reach in time. Htoo was 21 years old in November of 2015. She had recently given birth to a son she named Michael. Michael was 5 weeks old, barely a month in the world, a child so new that his features were still settling into the shape they would have carried through all the years of a life he did not get to live. Htoo was a young mother, and by the account of the court proceedings that followed, she was a young mother in profound distress. Postpartum depression, a serious and well-documented medical condition affecting a significant percentage of new mothers, was identified in the legal proceedings as a major factor in the circumstances of this case. That identification does not diminish what happened. It does not remove accountability. But it is a fact, established and entered into the record by the court, and it carries weight for anyone trying to understand how a 5-week-old child came to be in danger inside his mother's care. On November 19, 2015, Htoo prepared a mixture that she administered to her infant son Michael. The mixture, as investigators and toxicologists later determined, contained baby formula combined with sleeping medication and bedbug poison. She fed this to her 5-week-old son. When the mixture did not produce the outcome she had intended, Htoo took a further, deliberate action. She smothered the infant. Michael did not survive. Following Michael's death, Htoo placed his body in her vehicle. She then drove to Midway Parkway, a road in the St. Paul urban grid, and intentionally drove the vehicle into a light pole. The crash was not an accident. It was an act carried out with the deliberate purpose of taking her own life in the immediate aftermath of what she had done to her son. She survived the crash. Her son did not survive the hours before it. The investigation that followed Michael's death involved St. Paul law enforcement and the Ramsey County legal system. The toxicological examination and the autopsy established the cause of Michael's death. Htoo was arrested and charged, and the case moved through the courts over the months that followed. The legal proceedings in this case required the court to weigh two things simultaneously: the full facts of what had happened to Michael and the documented mental health context in which those facts had occurred. This is one of the most difficult balancing acts that any court in any jurisdiction is regularly asked to perform. The law must account for conduct. It must also account for the conditions under which conduct occurs, particularly when those conditions involve a documented and serious mental health crisis. The Ramsey County Court navigated this through the legal mechanism of a reduced charge. Htoo entered a guilty plea to first-degree manslaughter, a charge that carries serious consequences while acknowledging the distinctions the court found relevant in the circumstances of this particular case. In March of 2017, approximately 15 months after November 19, 2015, Htoo was sentenced to 15 years in prison. She was 23 years old. The sentence reflected the court's judgment about the weight of what had happened to Michael, while also acknowledging the documented mental health factors that had been established through the proceedings. 15 years. A sentence that the court arrived at through a deliberate process, in a case that forced a serious engagement with questions that do not yield easy answers. What does accountability look like when mental illness is present? What does justice mean for a child who is no longer here to receive it? How does a community reckon with the simultaneous truths that a young woman was in crisis and that her infant son lost his life because of what she did in that crisis? These are not questions that can be answered in a sentence or a script or a verdict. They are questions that every community carries with it, unanswered and ongoing, as it tries to build systems robust enough to catch people before they reach the floor. The postpartum mental health crisis that the court identified in Htoo's case is, by the data that exists on the subject, far more common than most communities acknowledge. It is a medical reality that affects new mothers across all demographics, all income levels, all geographies. It can manifest in ways that are invisible to outside observers. It can deepen quickly without intervention. And in the worst-case scenarios, it can place both mothers and their children in danger. If there is a preventive lesson in this case, And prevention is the purpose of honest examination. It is that the systems designed to support new mothers in mental health crisis must be accessible, non-stigmatizing, and present early enough to make a difference. Michael was 5 weeks old when he died. 5 weeks is not long, but it is long enough for a postpartum crisis to have been identified and addressed if the right resources had been available and engaged. Michael deserved the chance to grow into the person he would have been. That chance was not protected. And the 15 years handed down in Ramsey County in March of 2017 stand as the law's response to a case that leaves every honest observer with more questions than answers, and with a commitment to do better. Please take a moment to like this video, leave a comment, and subscribe to Cold Case Hour. Your engagement helps make sure stories like Michael's are never lost. Case 6. Jennifer Marie Stately, March 15, 2024, Federal District Court, Minneapolis. There are crimes that exhaust the capacity of ordinary language to describe them. There are cases in which the facts, laid out in their documented sequence, produce a silence in the people who hear them, a pause before the next sentence is possible, because the last sentence has landed somewhere too deep for an immediate response. The case of Jennifer Marie Stately is one of those cases. It is a case that moved through the federal justice system of the United States, that was tried in a Minneapolis federal courtroom, and that resulted in a verdict in February of 2026 that closed the legal chapter of a tragedy that began in northern Minnesota in the spring of 2024. Jennifer Marie Stately was 35 years old on March 15, 2024. She was a mother of 3 young boys, a 6-year-old, a 5-year-old, and a 3-year-old. They lived on the Red Lake Indian Reservation, a sovereign tribal nation in Beltrami County in northern Minnesota, a community with its own governance, its own law enforcement infrastructure, and its own relationship to both the state and federal legal systems. Because the Red Lake Reservation operates under federal jurisdiction for major crimes, the case that emerged from March 15, 2024, would ultimately be prosecuted not in a state court, but in the federal district court located in Minneapolis. On that March evening in 2024, Jennifer Marie Stately attacked her 2 older sons, the 6-year-old and the 5-year-old, with a knife inside their family home on the reservation. What followed has been established through the federal investigation, the trial proceedings, and the testimony presented over 7 days in a Minneapolis courtroom. The 6-year-old did not survive the knife attack. He was fatally injured inside the home where he had grown up, in the community where his family lived, by the person who should have been his first and most absolute source of safety. After attacking her sons, Stately set the family home on fire. She used gasoline as an accelerant. The 5-year-old, who had survived the initial attack, was inside the burning structure. He did not escape. The cause of his death, established through the forensic investigation, was carbon monoxide poisoning, the silent, invisible consequence of a fire that consumed the home around him while he was unable to get out. Stately fled the reservation following the fire. She took her youngest son, the 3-year-old, with her. His presence in the vehicle during her flight was the basis for an Amber Alert that was activated across Minnesota. Law enforcement from multiple agencies engaged in the search for Stately and the 3-year-old. The alert brought public attention to the case and to the location of the surviving child. Stately was apprehended approximately 150 miles south of the reservation in Todd County, Minnesota. The 3-year-old was recovered safely. The federal investigation that followed was extensive. The jurisdictional complexity of crimes committed on tribal lands under federal authority required coordination between tribal law enforcement, the FBI, and federal prosecutors. The case was built carefully, methodically, over the months and years that followed March 15, 2024. The evidence assembled, forensic, testimonial, and circumstantial, formed the foundation of a federal prosecution that would ultimately take 7 days in a Minneapolis courtroom to complete. In February of 2026, nearly 2 years after the events on the Red Lake Reservation, Jennifer Marie Stately stood trial before a federal jury in Minneapolis. The jury heard 7 days of testimony, reviewed the evidence presented by federal prosecutors, and deliberated on the charges. On February 25, 2026, the jury returned its verdict. Stately was convicted on 5 counts of first-degree murder and 1 count of arson. 5 counts of first-degree murder, 1 count of arson. For the 6-year-old stabbed inside his home. For the 5-year-old who did not survive the fire. For the lives taken from 2 young boys on a March night in 2024. The federal conviction of Jennifer Marie Stately represents the full force of the United States legal system's response to what happened on the Red Lake Reservation. The federal first-degree murder statute carries consequences that are permanent and severe. The jury's verdict, unanimous, after 7 days of evidence, was a collective judgment by 12 individuals who sat through the details of this case and arrived, together, at the same conclusion. The Red Lake Nation, in the aftermath of this case, faced the particular grief of a community that has known generations of loss and has learned, through necessity and through resilience, to carry that grief while continuing to build. The Red Lake Band of Chippewa is a community with a deep and complex history, with institutions of governance and culture and care that extend well beyond any single case or any single family. The pain of March 15, 2024, belongs to that community in a way that those outside it can acknowledge but cannot fully share. For the federal court in Minneapolis, for the prosecutors, the investigators, and the jury that returned the verdict of February 25, 2026, the 5 convictions represent the completion of a legal obligation to 2 children who deserve to be alive for the verdict. They were not, but their names are in the record. Their story is on the docket of the United States District Court, and the woman who took their lives will face the full weight of federal law for what she did. Justice was delivered. The children cannot receive it, but it was delivered in their names, and that matters. Please like this video, drop a comment, and subscribe to Cold Case Hour. These stories are told in honor of those who can no longer speak for themselves. Case 7. Jorden Borders Multi-Year Abuse. Uncovered February 2024, Minnesota. Most of the cases examined in this documentary involve a single act, a defined moment in time when something irreversible occurred, and the investigation that followed had a clear starting point. The case of Jorden Borders is different in its architecture, though not in its gravity. It is a case that unfolded not in a single day, but across years. Years during which 3 children lived inside a home, where what was being done to them remained hidden from the outside world, concealed by the routines of ordinary life, and the particular difficulty that investigators and social workers face when harm occurs inside a closed household over an extended period of time. The case against Borders came to light through investigative work that began in February of 2024, when the full scope of what had been occurring inside her household began to emerge. What investigators discovered when they examined the evidence was a picture of sustained harm, abuse directed at her 3 children over a period of more than 5 years. The duration of the abuse, and its systematic nature, distinguished this case from acts of impulse or isolated crisis. What happened inside Borders' home was not a single moment of failure. It was a pattern, ongoing, deliberate, and concealed. Jorden Borders was 32 years old when the investigation began to surface what her children had endured. The charges that were ultimately brought against her reflected the severity and variety of the conduct investigators established: extreme child abuse, attempted murder, and Medicaid fraud. The fraud charge added a dimension to the case that extended beyond the direct harm to the children. It indicated that the system designed to support vulnerable families had been manipulated in ways that served Borders while her children were being harmed. Among the disturbing findings that emerged from the investigation, and that were established in the legal proceedings, was evidence that Borders had engaged in a pattern of conduct involving her son's blood, repeatedly taking it in a manner that subjected him to ongoing harm, and had compelled her other children to participate in concealing what was happening. The involvement of siblings in the concealment of harm done to one of their number is among the more psychologically complex dimensions of abuse cases, reflecting the coercive power that an adult in a position of complete domestic authority can exercise over children who have no frame of reference for what is normal and no safe mechanism for disclosure. The investigation and prosecution of this case moved through the Minnesota legal system with the weight of evidence accumulated over the months following February of 2024. The charges required prosecutors to document not just individual incidents, but a sustained course of conduct, a more demanding evidentiary task than single-incident cases present, and one that required careful assembly of medical records, witness accounts, and forensic evidence. In August of 2025, Jorden Borders, by then 34 years old, was sentenced in a Minnesota court. The sentence handed down was 39 years in prison, 468 months. It was among the most significant sentences in recent Minnesota cases involving child abuse, reflecting the court's assessment of the duration, the severity, and the deliberate nature of what Borders had done to her children over more than half a decade. 39 years. For 5 years of sustained harm to 3 children. For the Medicaid fraud that ran parallel to the abuse. For the deliberate concealment. For everything that happened inside that home that the outside world did not see until February of 2024 brought it into the open. The children who survived this case face a recovery that will extend far beyond the legal proceedings that produced their mother's sentencing. Children who have experienced prolonged abuse within the home carry that experience in ways that manifest across years and decades, in their relationships, in their sense of safety, in their understanding of the world and of themselves. The therapeutic and social support systems that exist for child abuse survivors in Minnesota are, like all such systems, imperfect. But they are present, and they are staffed by professionals who understand the complexity of what these children carry. The exposure of this case, and the 39-year sentence that followed, represent accountability in its most formal sense. But the deeper accountability, the accountability that a community owes to children who survive experiences like this one, is ongoing, and it requires resources, attention, and a willingness to look at what happens behind closed doors with clear eyes. Borders' children endured what no child should endure. They survived, and the law has responded in a way that marks their survival and honors what they went through. If this case moved you, please like this video, leave a comment, and subscribe to Cold Case Hour. Your support ensures that stories like these reach the widest possible audience. Case 8. Jocelyn Leslie Pater, December 16, 2022, Mower County. Not all cases arrive with the dramatic architecture of premeditation and flight and multi-agency investigations. Some cases arrive quietly, as terrible as the loudest ones, in the ordinary settings of everyday life. On a couch in a small apartment in a mid-sized city, in the hours of an ordinary evening when one decision, one moment of negligence, one set of circumstances converges with an irreversible consequence. The case of Jocelyn Leslie Pater in Austin, Minnesota, is one of those cases. It is quieter in its outward presentation than others examined here, but the child at its center, 2 months old, not yet capable of the simplest self-protective act, is no less present in it. And the questions it raises about substance use, about infant safety, and about the systems designed to prevent exactly this kind of tragedy are no less urgent. Jocelyn Leslie Pater was 24 years old on December 16, 2022. She lived in Austin, Minnesota, the seat of Mower County, approximately 100 miles south of Minneapolis, a city of modest size, known for its manufacturing heritage and for the particular culture of a small Midwestern city where community connections run deep and the loss of a child in almost any context sends ripples through multiple overlapping social networks. Pater had a 2-month-old son. On the evening of December 16, 2022, she fell asleep on a couch while holding her infant. The infant did not survive. The investigation that followed Pater's call to emergency services established the circumstances of the infant's death. The medical examiner's findings indicated that the child had been asphyxiated, suffocated by the physical circumstances of being held by an adult who had lost consciousness while in an impaired state. That impairment is the detail that moves this case from the category of tragic accident, the kind of terrifying outcome that safe sleep advocates work tirelessly to prevent, which can occur even in completely sober households, into a different category, one that the law treats accordingly. Forensic toxicology testing conducted as part of the investigation produced a finding that shaped the prosecution's approach to the case. Testing of the infant revealed the presence of methamphetamine in his system at the time of his death. This finding indicated that the child had been exposed to the substance, through the proximity of his caregiver, through the environment he lived in, through the physiology of an infant who is entirely at the mercy of the air he breathes and the substance of the care he receives. The presence of methamphetamine in the system of a 2-month-old is not an abstract finding. It is a direct indicator of the conditions under which he was living. Jocelyn Leslie Pater was charged with second-degree manslaughter in Mower County, a charge that reflects criminal negligence resulting in death, without the element of intent that elevates charges to higher degrees. The case moved through Mower County District Court, and in October of 2023, Perdew entered a guilty plea. She was 26 years old at the time of her sentencing. The sentencing proceeding in this case produced an outcome that differs from most of the cases examined in this documentary, and that difference is worth examining honestly. The judge in the Mower County case reviewed the facts, the circumstances, the history presented by the defense and the prosecution, and reached a decision that reflected the particular legal tools available in the Minnesota sentencing framework. The judge stayed the sentence, meaning that the 57-month prison term that would otherwise have been imposed was held in abeyance, and placed Perdew on 5 years of supervised probation instead. Prison time was not executed. This outcome has been the subject of varied response in the community and in broader public discussions about the sentencing of individuals in cases involving infant death. The decision to stay a sentence reflects a judicial determination that, in the specific circumstances of this case, supervised probation offered a more constructive path than immediate incarceration. It is a legal option that exists precisely because the law recognizes that cases and individuals exist on a continuum, and that the response to harm is not always best served by a single formula. Reasonable people may reach different conclusions about whether the outcome in this case reflected that principle appropriately. What is not subject to reasonable disagreement is the cost borne by a 2-month-old child who entered an environment he did not choose and could not escape. He deserved clean air, a safe sleeping arrangement, and a caregiver who was present and alert during the hours he was most vulnerable. He received something different, and he did not survive the difference. The Mower County proceeding, whatever one's view of the sentencing outcome, placed Jocelyn Leslie Perdew within a formal legal accountability structure for 5 years. The terms of supervised probation carry requirements that are meant to address the circumstances underlying the offense. Whether those terms are sufficient, and whether they serve the memory of a 2-month-old child adequately, is a question that the community, the advocates, and the legal analysts continue to engage with. Austin, Minnesota lost a child on December 16, 2022. The court has responded. The record has been made. And the infant at the center of this case deserves to be remembered with the same seriousness that his short life demanded. Please like this video, leave a comment, and subscribe to Cold Case Hour. These stories deserve to be heard, and your support helps ensure they are. Case 9, Larena Jackson, August 21, 2023, Cass County. There is a particular feature of certain criminal investigations that investigators describe with a specific kind of gravity. The moment when the physical evidence of a scene contradicts the account that has been provided, not in small ways, not in ways that can be explained by error or misunderstanding, but in ways so definitive that the contradiction becomes itself the central piece of the case. The investigation into the death of a 23-month-old child in Cass Lake, Minnesota, in August of 2023 is one of those cases. It is a case where the scene said one thing and the initial account said another, and where the investigators who searched a home in northern Minnesota found evidence that turned what had been presented as a tragic accident into a criminal homicide prosecution. Cass Lake is a small community in Cass County in north-central Minnesota, situated on the shores of the lake that shares its name, at the edge of the Leech Lake Reservation. It is the kind of northern Minnesota community where the rhythms of life are shaped by the land and the water and the seasons, where everyone tends to know something about everyone else, and where a call to emergency services on a summer evening draws attention. On August 21, 2023, law enforcement received a call from Larena Jackson, 30 years old, reporting that her 23-month-old son had been accidentally run over by a vehicle. The responding officers and investigators began their work in the immediate aftermath of that call, examining the scene, speaking with Jackson, and initiating the investigation that any unexplained child death requires by protocol. The initial account, accidental vehicle strike, was one that investigators needed to evaluate against whatever the physical evidence showed. In this case, the physical evidence showed something very different from what Larena Jackson had reported. The search of Jackson's home in Cass Lake produced findings that fundamentally altered the trajectory of the investigation. Investigators discovered substantial quantities of blood hidden within the structure, on surfaces that suggested an attempt had been made to conceal what had occurred inside the home. They discovered deep indentations in the drywall that, in their shape and placement, were consistent with a small child's body having been impacted against the wall with significant force. The size and configuration of these indentations corresponded to a toddler, a child of approximately the dimensions of a 23-month-old. The evidence found in the home told a story entirely different from an accidental vehicle strike. It told a story of harm occurring inside the residence, of force applied to a very small person, of an attempt to construct an alternative account that would divert investigators from what had actually happened. The investigators were not diverted. Faced with the evidence gathered from the home, and with the contradictions between that evidence and her initial account, Larena Jackson later acknowledged to investigators that the account she had provided was not accurate. She acknowledged that her son's injuries had not been caused by a vehicle, and she acknowledged that she had been severely under the influence of illegal substances at the time the events occurred. The investigation, building on the physical evidence from the home, the medical examiner's findings regarding the injuries, and Jackson's subsequent acknowledgement, formed the basis of the criminal case brought in Cass County. Jackson was charged with second-degree murder, a charge reflecting the intentional infliction of injuries severe enough to cause a child's death. The case moved through the legal process over the months and years following August of 2023. In March of 2025, approximately 19 months after that August evening, Larena Jackson entered a guilty plea to second-degree murder. She was 30 years old when she stood before the court for sentencing. The judge reviewed the facts of the case, the evidence that had been assembled, and the circumstances of what had happened to a 23-month-old child in a home in Cass Lake. The sentence handed down was 17.5 years in prison. 17.5 years for the death of a child who was not yet 2. For the blood on the mattress and the indentations in the drywall. For the false account that had been designed to misdirect the investigation. For what was done to a toddler in Cass Lake on August 21, 2023. The role of illegal substance impairment in this case, as in several others examined in this documentary, is a dimension that community advocates and public health professionals in Minnesota continue to grapple with. The relationship between substance use disorder and harm to children in the home is a documented and serious public health concern, one that requires both accountability mechanisms and accessible treatment resources to address. The availability of substance use treatment in rural, northern Minnesota communities, where the infrastructure of support services is thinner than in urban centers, where distances to treatment facilities can be significant, and where the stigma associated with seeking help can be a substantial barrier, is an ongoing challenge that the death of children in circumstances like this one makes impossible to ignore. None of that analysis offers comfort to the people who knew a 23-month-old child in Cass Lake, who watched him grow from an infant into a toddler, who saw his face and heard his voice and could not protect him from what happened inside that home on an August night. For those people, the 17.5-year sentence handed down in March of 2025 is a legal accounting that the law could provide. The grief they carry is something the law cannot reach. The child at the center of this case deserved to reach 2 years old. He deserved the summer days and the winters and all the ordinary moments of a northern Minnesota childhood. That future was taken from him, and the court in Cass County has responded with the seriousness that loss demands. Please like this video, leave a comment below, and subscribe to Cold Case Hour. Your support ensures that children like this little boy are remembered and never forgotten. Case 10, Shiann Lynn Erickson, March 18, 2024, Clay County. The final case in this documentary is, in several important ways, distinct from those that have come before it. Every other case in this episode involves a biological mother, a woman whose connection to the child she harmed was the foundational, irreducible bond of parenthood. This case involves something different, a caregiver, unrelated by blood, who had been entrusted with the temporary care of a child not her own. The distinction matters not because it diminishes the gravity of what occurred, nothing could, but because it opens a different set of questions about the structures of informal child care, about the accountability of adults who take on caregiving responsibilities outside the formal systems of licensed foster care or adoption, and about the particular vulnerability of young children placed in the care of people whose commitment to their well-being has not been tested or verified over time. Easton Durangic was 3 years old. He was not Shiann Lynn Erickson's son. He was a small boy who had been placed, through circumstances that the investigation would examine, in the care of Erickson and her boyfriend, Mason Garza, at a Moorhead apartment. Moorhead sits on the western edge of Minnesota, directly across the Red River from Fargo, North Dakota, a mid-sized city in Clay County that functions as a regional center for the surrounding area. The apartment where Easton lived during this period was his day-to-day world, the place where he slept and woke and spent the hours of a 3-year-old's life under the supervision of 2 adults who had no formal relationship to him and no formal accountability structure governing their care of him. Easton had been in the care of Erickson and Garza for several months by the time of March 18, 2024. The arrangement was not a licensed foster placement. It was an informal caregiving situation, the kind that occurs far more commonly than formal systems capture, in which a child ends up in the care of adults who are connected to the child's family through personal relationships, circumstance, or convenience rather than through the formal channels that carry with them training requirements, oversight visits, and legal accountability. On March 18, 2024, emergency services were called to the Moorhead apartment. The responding personnel found Easton Durangic unresponsive. He was 3 years old. The medical examination that followed would establish the cause and nature of what had happened to him. The findings presented an image of harm so extensive and so deliberate that investigators were left in no doubt about the criminal nature of what had occurred. The medical examination documented 28 distinct areas of injury on Easton's body. 28. On a 3-year-old. The injuries reflected a pattern of harm consistent with repeated force applied to a very small child over what the evidence suggested was not a single incident, but a pattern of conduct. The specific cause of death, as determined by the medical examination, was a ruptured bowel, an internal injury caused by a severe blow to the abdomen, the kind of force required for such an injury, placing the conduct that caused it beyond any plausible interpretation other than deliberate harm. The investigation produced charges against both Shiann Lynn Erickson and Mason Garza. The case against each of them moved through the Clay County legal system, accounting for the respective roles established by the investigation. In May of 2026, Shiann Lynn Erickson, 24 years old, was sentenced to 15 years in prison for second-degree murder in connection with Easton's death. Her boyfriend, Mason Garza, received a 20-year sentence, a difference that reflected the court's assessment of the respective conduct and culpability of the 2 individuals involved. 15 years for Erickson, 20 years for Garza. For Easton Durangic, 3 years old, 28 documented injuries, and a death that should never have happened in an apartment where he had been left in the care of adults who bore no formal responsibility and, the evidence suggested, exercised no adequate protection. The informal care arrangement at the center of this case is a structural vulnerability that exists in every community. Children end up in the care of people outside formal systems for countless reasons: family emergencies, economic pressures, the absence of accessible formal care options, and the basic human reality that families are complex and arrangements do not always follow formal channels. Most informal care arrangements do not end in tragedy, but the ones that do reveal the gap between the care that children receive within regulated systems and the care that children receive outside them, and they demand a serious conversation about how communities can better protect children in informal care from the harm that formal systems are at least theoretically designed to prevent. Easton deserved better. He deserved the ordinary days of a 3-year-old life, the running and the questions and the laughter and the completely unremarkable safety of a childhood that continues. The Clay County Court, in May of 2026, handed down sentences that reflected the seriousness of what was taken from him. And the record of this case will stand as testimony to what happened and to the community's obligation to make sure it happens less. Before we close this episode, we want to acknowledge all the children whose stories have been shared here today. Each of them deserved safety, protection, and the full measure of their lives. If you have concerns about the safety or welfare of a child in your community, please reach out to the Child Help National Child Abuse Hotline at 1-800-422-4453. Advocates are available 24 hours a day, 7 days a week, and every call has the potential to change a child's life. Cold Case Hour is committed to responsible, fact-based, and respectful documentary storytelling. The cases examined in this episode are drawn from verified court records and publicly documented legal proceedings. Every story here is told in honor of the victims and in service of the accountability and awareness that communities require to protect their most vulnerable members. If this episode has moved you, educated you, or given you reason to reflect on the systems and structures that surround child safety in your community, please like this video, leave your thoughts in the comments section, and subscribe to Cold Case Hour if you have not already done so. Hit the notification bell so you never miss a new episode. Your support is what keeps this channel going, and every subscription, every comment, and every share helps these stories reach people who need to hear them. Thank you for watching Cold Case Hour. We will see you in the next episode.